Everybody, welcome to this first breakout panel session, wherever you are in the world and whatever time it happens to be, wherever you are. My name is Jeff Crisp. I'm affiliated both to the Refugee Law Initiative in London and to the Refugee Studies Centre in Oxford, which is where I'm speaking from right now. And it's my great pleasure and privilege to be the chair for this opening panel session, which is addressing an issue which is very directly related to the overall theme of the conference. And we'll be looking at the question or the issue of improving the refugee regime, framing the issues. Given the limits of time, I'm not planning to do a lot of long introductions either to the people who are speaking or to the papers. I would refer you to pages 14 to 16 of the program, where you will find details of the speakers and abstracts for each of the 4 papers that are about to be presented. So in brief, we are going to start with Brian Gorlick, who's going to provide a paper titled Solutions Are in the Eye of the Beholder. We'll then move on to Hannah Gary, From Policy Back to Principles. Our third speakers will be Philip Burton and Catherine Allison, who will be questioning the origin story of the global refugee regime. And then our final speaker will be Shadin Al-Majri. Her paper is titled Protecting by Origin, Nationality-Based Differentiation in Refugee Protection and Aid Policy. So without further ado, let's get on with the papers. Please feel free to ask any questions or to submit any comments in the chat function, which you should find on your screen. And after the 4 speakers have spoken, then we'll turn to the audience and I'll be reading out some of the questions and comments submitted in the course of the preceding few minutes. So without further ado, let me first invite Brian Gorlick to take the floor and to speak about solutions are in the eye of the beholder. Thank you, Brian.
Thank you, Jeff, and thank you to the organizers for inviting me and to the fellow panelists who I'm meeting for the first time, which is always terrific to meet new colleagues who are working in this field. And, you know, briefly about myself, there is a bio, but I worked for the UNHCR as well as Jeff. And Jeff, to my mind, was always one of those free thinkers in UNHCR who I really appreciated and still do for many years. And I worked in the Secretariat in New York in another capacity for half a dozen years, in total about 27 years in the UN bureaucracy, and it was a privilege, and largely with a terrific bunch of colleagues. But there was also times when it was rather frustrating. It is a big bureaucratic institution, the UN, UNHCR is no exception, and sometimes you would wish to change things and you couldn't. And that's kind of one of the themes that I am going to address in this paper. And I also want to, you know, in that regard, acknowledge the terrific work that UN does and UNHCR does. It's rarely easy, but it's important and it's valuable, but it is difficult. And full respect as well at the outset to refugees who, to my mind, in many instances are their best protectors and providers and decision makers, never mind what others do on their behalf. They basically take care of themselves in many instances. And we also have to acknowledge that the UN and UNHCR is perhaps not as influential as it would wish to be or could be. And part of that is by design. I think powerful states would not be that keen on having multilateral institutions and entities that are beyond their control, although there's currently plenty of control. And there's also a degree of bureaucratic resistance, and it has to be said, institutional arrogance that doesn't make change easy. But in my remarks today, I'll address some big picture items, and I'll also address some getting into the weeds of how I think, or at least propose, the UN Refugee Office could be possibly less state-driven, more protection-oriented, inclusive. But at the outset, let's think big. And the big picture is as follows, and we all live in this world, and we know that power politics tends to dominate a lot of what's going on in the world today, and including the creation of conditions that create refugees. And there's a fierce and intense competition between the US, the United States, and the Western Alliance, China, Russia, and India in its own spheres of influence. And it also has to be acknowledged that there's deep ideological and political differences, as we see starkly in the war and conflict in Ukraine and Myanmar as just 2 examples. And we live also in a world where good governance, if I can use that term, is lacking for possibly 70% of the world's population. The Stockholm-based International Institute for Democracy and Electoral Assistance, IDEA for short, in a 2021 report, identified 98 countries out of a global 195 as democratic, 20 hybrid, meaning slipping towards dictatorship, and 47 clearly authoritarian. The latter two categories constitute 70% of the world's population. Transparency International, another well-known entity, has found that nearly 1 in 4 people paid a bribe for public services globally. And countries experiencing armed conflict or authoritarianism, not surprisingly, tend to earn the lowest scores on the Corruption Perceptions Index. So in that regard, calls for an international anti-corruption court are not misplaced. And to my mind, authoritarian governments and systemic corruption are reasons alone to leave one's country. When we speak about asylum, states commonly shape their policies and practices with a view to controlling numbers in the name of security. While there are several positive examples around the globe of states hosting large numbers of asylum seekers and refugees, there's also a depressing number of aggressive and ill-advised instances of externalization and containment practices. That said, what the war in Ukraine demonstrates is that if states and communities have the political will to receive and host large numbers of refugees, it can be done. However, poor state practices and their global ripple effects continue. Collectively, the restrictive approaches deny access to territory and due process rights of the asylum state, and they really stretch the imagination of what jurisdiction means in a domestic context. In addition to the astronomical expense and human cost of various immigration control measures, we can all expect extensive litigation to sort out the messy legal issues, as I saw the day after the UK was to implement its Rwanda MOU arrangement. There was already somebody in court the day before trying to put a stop to it. But to be clear, the examples and measures that are control-oriented are considered solutions to controlling numbers of uninvited migrants, whatever their background and status, by state actors. So again, solutions in the eye of the beholder. There's also a concern about states' asylum policies influenced by racism or fear of the other. The situation in Ukraine raises the spectacle of white Ukrainians being admitted en masse to asylum countries, notably under special protection and visa arrangements, including on the other side of the globe from Ukraine, while asylum seekers and refugees from Africa, the Middle East, and Central America are denied entry. However, 86% of the world's refugees, as we know, and asylum seekers, stateless, and IDPs reside in the global south, and that reality is unlikely to change. Another reality is that only 20 countries out of 195 nation states are hosting more than 75% of the world's refugee population. And of the 10 countries that received the most refugees per capita during the period of 2011 to 2021, only one Western country, Sweden, at 2.6%, made the list. In today's complicated political world, I find it surprising still that UNHCR's voice is so muted. Significant resources are spent on zealously promoting its image and flashy branding, falling into a common pattern of institutional competition for donor and public support. And while not detracting from the efforts of some terrific goodwill ambassadors and public relations colleagues, the net benefit of these efforts, given the enormous expenditure, is difficult to gauge and questionable in my mind, given the use of public funds. When it comes to challenging states, there are some exceptions. Again, I'll refer to the UK, where a number of colleagues in this conference is based, where UNHCR has used strong language to denounce the UK-Rwanda agreement. However, it is often the case that UNHCR is content to soft pedal language and propose broad policy prescriptions, as we see in discussions around the Global Compact on Refugees. There are, of course, very commendable practices of UNHCR challenging legal decisions by submitting amicus briefs and engaging in strategic litigation across diverse jurisdictions, but one can point to several examples of where the office chose intentionally to remain silent. If a controversial issue comes up, then colleagues in the field, I was one of them, Jeff's been one of them, we're expected to seek guidance from headquarters in Geneva or from now Regional Bureau. But given the nature of a large bureaucratic structure, sometimes those instructions or inputs never come back, or they're slow, or they're too late, resulting in staff choosing or being told not to speak out. And if an important donor country is involved, then the likelihood of challenging their views diminishes. Another scenario, regrettably, is that UNHCR's advice is often commonly or simply ignored. UNHCR colleagues who do stick their necks out take personal risks. Over the years, several highly regarded colleagues have been kicked out or sidelined by a surprising number of countries, including those who are otherwise strong supporters of the global refugee regime. And if that occurs, I assure you, good luck if the organization supports you. Speaking truth to power and sharp responses from governments are not the only hazard of doing humanitarian and human rights work. As we know, over the years, hundreds of humanitarian staff from UN and civil society organizations have been physically and psychologically harmed and killed while performing their duties, and many of those individuals are local staff. Globally, again, to zoom out, overseas development assistance to refugee situations is currently $22.3 billion per year. Top 10 donors are US, Germany, and the EU countries that make up 50% of that total. In contrast, global military spending has been reported by the Stockholm-based CIPRI as exceeding now $2 trillion. Just, the figures are always interesting to play with. That's 2,000 times the ODA refugee-related figure. The United States, UNHCR's largest donor, as many know, contributes approximately 40% of the office's budget, and European Union-based countries, Norway and Japan, another 35%. The political economy of those figures alone help explain some of UNHCR's constraints. While no one state or group of states should have outsized influence, the reality is that several states do. Important donors, even those few that provide unearmarked or core funding, are never shy about pressuring UNHCR to step up, scale down, hold the line, or otherwise not interfere in domestic politics. And in this way, UNHCR's dependency on a handful of Western states for operational budgetary support does constrain the office's ability to carry out its basic supervisory protection function. And this dilemma is increasing as institutionally UNHCR has become par excellence an emergency humanitarian relief agency more than anything else. And this particular approach really took off during Sadako Ogata's time as High Commissioner. In the first few years of her tenure, UNHCR experienced massive growth, doubling in size and budget over just a few years. And since then, UNHCR's financial needs have never stopped growing, although the office has a perennial funding shortfall of approximately 48%. So fundraising as a consequence never stops. However, I would submit that rather than trying to deliver on everything, why not let the World Food Program run cash assistance and humanitarian logistics everywhere, or let competent NGOs build schools, hospitals, water systems on their own for refugees without UNHCR being overpriced subcontractors or would-be coordinators. UNHCR currently has raised millions of dollars of assistance for Ukrainian refugees, much of it from the private sector, with the bulk of it going to cash assistance that could be equally well managed by NGOs or banks directly. Meanwhile, African and Afghan refugees, Yemeni IDPs, and Rohingya refugees, and millions more see international funds diverted away from them towards the Ukraine crisis.
2 more minutes, Brian, please.
Okay. I submit that courageous leadership is key, but we also have to recognize that states appoint leadership, and leadership in turn appoints other leadership. And so there's a degree of loyalty. It may not seem so strange, but it does compromise sometimes independence when you're always having to look to those same donors and states to fund and support your candidacy and your programs. And you don't want to annoy the big donors, because if you do, then you'll have difficulties. Another political challenge we face, and something that I would suggest the Secretary General, former High Commissioner Antonio Guterres should do, is make noise about reform in the UN system, particularly when we're speaking about the Security Council. One of the challenges in the Security Council today is that it is certainly not representative, and it is not functioning as it should. And although we've seen the General Assembly and the Human Rights Council stepping up in a much more forthright way, real power rests with the Council and reform is required. And where is the Secretary General speaking about it, as his predecessors Boutros Ghali and Kofi Annan certainly did? In terms of staff as well, there is a degree of privilege, and that privilege is what I represent. It is white, it is Western, and it is male. And if you look at the staffing tables of UNHCR professional staff, 52% of the 3,400 approximately professional staff are from the global south. However, that region makes up 85% of the world's population. Several Western countries, including two of my own, Canada and Sweden, France, Italy, Germany, Australia, Bosnia, and the UK, amongst others, disproportionately represent professional staff in the UK. Meanwhile, populous countries like Bangladesh, India, Nigeria, Egypt, Russia, Turkey, and China make up only 173 of the total of approximately 3,400. Last point, many countries and NGOs, and this is a welcome message, are stepping up and raising the issue of refugees being at the table. And to quote Shirley Chisholm, who was a Democrat presidential candidate from years past, if they don't give you a place at the table, bring a folding chair. Many refugees are taking that approach, and I would suggest that it would also be very helpful for refugees to be at the table in terms of UNHCR staffing. It's unclear to me, I just know anecdotally of the number of refugees or former refugees who've made their way into the UN and UNHCR, some of them to senior positions. But I think it would be very meaningful if one day we had a woman with a lived experience as a refugee heading UNHCR and similarly as Secretary General. And I think we should start advocating in that regard. We should also move away. Last point, Jeff. We should also move away. Yeah, sorry, apologies, but just we should also move away from donor-driven practices such as having a U.S. national as Deputy High Commissioner for Refugees. With one exception, this has always been the case. A British national as Undersecretary General for Humanitarian Affairs, a French national heading peacekeeping, an American to head UNICEF, and a Russian citizen to head the UN office in Geneva. These old boys practices, although the current DHC, Executive Director of UNICEF and Director General of UNOG in Geneva are currently women, have no place in today's UN. I'll stop there. Thanks for listening, and I look forward to the discussion and any questions.
Thank you very much, Brian, for that very broad introduction to the topic, with a particular focus on UNHCR, which is, of course, very much at the heart of the refugee regime. I might come back and ask you whether it was quite a sobering scenario, and I may come back later and ask you if you see any grounds for optimism looking into the future. But let's move straight to our second speaker, Hannah Gary. And I think Hannah is actually going to focus on an issue that came up quite strongly at the last RLI conference, which was the whole question of whether there's a need for some kind of independent supervisory mechanism within the global refugee regime, particularly in view of the constraints that Brian has already outlined in respect of UNHCR. So without further ado, let me give the floor to Hannah for her presentation. Thank you very much.
Well, thank you so much, Jeff, and good afternoon, everyone. It's really an honor to have been invited to present here at RLI's annual conference and to participate on this panel in particular. I want to thank the conference committee and my distinguished panelists and Dr. Chris for moderating us today. So the title of my talk, as Dr. Chris just mentioned, really reflects my work in the area of reconsidering or retaking up the research that's already been done, but rethinking again whether we need some sort of independent international mechanism for vis-a-vis state compliance or non-compliance with their legal obligations for refugee protection under international law. And what I'm going to share with you today reflects the work that I'm currently undergoing on a first draft of a paper that's part of a larger project, which I got to launch this past term at University of Oslo's Pluricourt Center and its law faculty as part of a Fulbright scholarship. It's intended to be the first of hopefully several papers that will lead to hopefully informing future policy and perhaps lawmaking on this topic. And so the overall research questions are really whether, first of all, the international community should reconsider establishing a specialized international mechanism or court for enforcing refugee protection under international law. If so, second, what model of jurisdiction would be appropriate? And third of all, how to establish such a jurisdiction? In other words, what would be the necessary legal processes and political context that would allow for plausible establishment of such a mechanism, and how that might inform what would be the best model for such a jurisdiction. Since I first began working with refugees as a field researcher way back in the 1990s, when I was working with Oxford Refugee Studies Center in East Africa, the headlines vis-a-vis refugees are the same as they are today, quote unquote, worst refugee crises since World War II. And back then the numbers were over 15 million, give or take. Now, according to UNHCR's latest Global Trends report, coupled with its data portal on the Ukraine war, we're looking at numbers approaching over 40 million refugees and asylum seekers. And as the crisis has magnified, so too have states' non-compliance with their legal obligations to protect refugees under international law. And in fact, we've seen increased violation of refugee rights, particularly in the global north. So for example, we've seen the increase in the following policies and strategies. First of all, militarization of borders. Second, criminalization for those seeking asylum irregularly, while narrowing regular pathways for seeking protection or asylum. Third, increased deterrent strategies such as separation of families, indefinite detentions, pushbacks, offshore processing, and deportations to first countries of asylum, or so-called safe third countries, as we've seen recently with the UK vis-a-vis Rwanda. Fourth, increased refoulement to situations where refugees' lives are threatened and endangered. And finally, weaponizing of refugee flows at borders of other countries, as we saw recently with Belarus vis-a-vis Poland in retaliation for EU sanctions. Further, there continues to be disproportionate burden or responsibility sharing in violation of international principles of cooperation and sovereign equality of states. Over the last few decades, the vast majority of states have been content to let a handful of states, usually those at the border in the global south, with Germany being the exception, physically hosting the vast majority of refugees. In addition, the financial responsibility for humanitarian assistance has been disproportionately carried by a handful of states. The big exception, of course, to all of this has been the recent war in Ukraine, where Ukrainian refugees have largely been received by countries in Europe with open arms. However, this further highlights the problem that protection for refugees under international law is often dependent upon political will rather than being upheld out of a sense of legal obligation. So protection is upheld in a selective and discriminatory manner, depending on refugee origins. As was noted just this month by the Norwegian Refugee Council, quote, the war in Ukraine has highlighted the immense gap between what is possible when the international community rallies behind a crisis and the daily reality for the millions of people suffering far from the spotlight, unquote. So in light of this current situation, the overall aims of this research are really to examine the growing gap between the existing global legal framework for refugees and the facts on the ground, to examine the parameters of refugee protection as inclusive of legal protection, not just quote unquote operational protection, and to respark and build upon the debate as to whether and what kind of international mechanism might be established to effectively enforce these legal obligations, or whether the focus should remain as it is on a soft law policy approach vis-a-vis the current trajectory, with emphasis on policymaking through global governance mechanisms such as the 2018 Global Compact for Refugees for responsibility sharing. The question is, which is the better approach at influencing state compliance for refugee protection under international law? If the research shows that there's now a need for some kind of specialized mechanism in the face of a mounting crisis, should it be one with binding authority to enforce legal obligations like an international court? How should it be designed vis-a-vis the existing global refugee regime? And what would be the necessary processes and political context for establishing it? No proposals in the literature to date have gone so far as to seriously explore an international independent mechanism with binding decision-making authority in light of political realities. But setting that aside, specific questions to further explore would be whether a proposed mechanism should first focus on authoritative interpretation of the law versus particularized assessment of compliance through fact-finding or individual claims. Second, whether it would be only seized by states or by entities, non-state entities, or individuals such as individual refugees. And third, whether it would be able to hear other claims related to root causes and accountability for refugee flows. Further issues to assess include what would be the nature of its relationship to national courts or regional jurisdictions where there's overlapping jurisdiction, what would be its relationship to non-state parties to relevant treaties, and finally, what would importantly, what would be its relationship to UNHCR. Preliminary findings so far in the work are as follows. First of all, in spite of the hard law foundation for refugee protection under international law, with the core treaties being the 1951 Refugee Convention and 1967 Protocol, the global regime has, from its inception, emphasized refugee protection as a humanitarian operational concept, almost as charity, whose implementation largely depends on political will, over it also being a legal obligation with legal concept with both rights and obligations. And this is increasingly the case in the past few decades and is a worrying trend that has coincided with the increased non-compliance by states with those obligations. Second of all, from the beginning, and as was mentioned earlier, probably deliberately so, the means or mechanisms for interpretation and implementation of refugee protection as legal protection have been weak. This is evidenced in a number of ways. First of all, in the core treaties from the beginning, they were among the few post-World War II without a dedicated treaty mechanism for enforcement. Second of all, UNHCR, while named as a supervisor for the core treaties, has primarily been emphasized in its role as a humanitarian non-political body with a mandate to facilitate operational protection for refugees, thereby compromising its supervisory mandate to fact find and to put pressure on and encourage states to uphold their legal obligations to protect refugees. UNHCR has, by design, inherent structural conflicts of interest for its supervisory role due to its reliance on states for access and resources for refugees. And where it has spoken up, and it was refreshing to see it really speaking up and criticizing the UK recently vis-a-vis Rwanda, it hasn't done so consistently, and also there's been a lack of transparency and consistency in doing so. Also, UNHCR as a supervisory body has not been fully independent ever from states, as demonstrated by the fact that it wasn't even a permanent body until 2003, and it still has to solicit, as was mentioned in the previous comments, voluntary contributions to fulfill its humanitarian mandate on a regular basis. Finally, with UNHCR's role in encouraging states to uphold legal obligations, while it does provide interpretive guidance on refugee protection and has provided helpful guidance, this has often been treated as persuasive authority at best by countries. It hasn't always been followed as legitimate and has not been entirely comprehensive to meet the need. Third, with regard to existing means, we have the International Court of Justice. It's explicitly stated as a dispute resolution mechanism in the core treaties, but it has not been used. Further, it's a court of general jurisdiction, not specialized in refugee protection matters under international law, and arguably does not have the capacity to meet the need for the numerous issues that have arisen and continue to arise with interpretation and enforcement of refugee protection under international law. Finally, with regard to means, we have this shift in focus on soft law instruments under the New York Declaration and 2018 Global Compact for Refugees in furtherance of operational protection through monitoring of voluntary pledges and commitments by states, but a host of other stakeholders. While international legal principles are affirmed, particularly for responsibility sharing, emphasis is on political processing modalities for cooperation over the language of rights, obligations, and reciprocity under the law. And there's a danger that legal principles will be undermined in the process. Further, there is a lack of robust implementation or enforcement mechanisms for this voluntary commitments framework. A third conclusion of the research is that from the beginning of this global refugee regime that we have at the moment, implementation and enforcement of protection under the law has been largely then left to be enforced through domestic and regional jurisdictions, both judicial and quasi-judicial, mostly without any specialized jurisdiction in refugee issues, and has led to ad hoc, fragmented, and selective interpretation and accountability for violation of legal principles. My fourth and fifth conclusions I'm just going to briefly touch upon have to do with the proposals that were put forward in the literature from 2001 to 2013, and recently with regard to thinking about an international independent mechanism. A number of these were focused more narrowly on a definition of legal protection for refugees that focuses on the core treaties rather than the larger body of international law that's also applicable, both under treaty and custom in other subject matter areas, including human rights, humanitarian law, criminal law, law of the sea, et cetera, and focused on protection in exile rather than also addressing root causes or accountability for refugee flows. Further, these proposals largely recommend some sort of connection to UNHCR and the UN, so they lack independence, and they're often split in the terms of their mandate between being interpretive versus accountability mechanisms. Also, the debate around this topic has really dried up in the face of this new focus on the global governance strategies through the Global Compact for Refugees. A sixth conclusion in the research is that there still remain a number of legal and factual justifications, and even new ones now, for such a mechanism. They persist today, and in light of the resulting developments with the processes around the Global Compact for Refugees. These include insufficiency of these means for ensuring enforcement of protection under the current regime, the continuing need for some authoritative pronouncement on the full scope of the applicable law and the applicable norms, and coherency in their interpretation in the face of complex factual situations, as well as a need for consistent accountability for breaches of the law. At the same time, there are serious counterarguments related to geopolitical realities, timing, the fact that an international specialized mechanism may not, in fact, actually lead to better state compliance with international legal norms. And there's a host of complexities around design and implementation of such a mechanism.
Okay. Just one more minute, please.
All right, thank you. Finally, my last conclusion is that if one does view protection, refugee protection under international law as an impure global public good, as has been put forth in the literature since the 90s, or as a global governance strategy, establishing such a mechanism for enforcement that is more centralized, where it is independent and more coercive in nature, perhaps even with binding decision-making authority as an intermediate global public good, could potentially right the balance in approach under the current regime by returning the system towards its hard law roots, treating refugee protection as consisting of rights and obligations, not something that is simply charity or humanitarianism, subject to politics and policymaking, and coexistence of such a mechanism with existing global governance strategies, if well designed, may be better aligned with our understanding of effective global governance, serve as an important part of it, and have potential to better achieve more holistic protection for refugees and global stability and security, where upholding rule of law is balanced with humanitarianism. Thank you so much. I look forward to the discussion.
Great, thank you very much indeed. I was interested that you mentioned the Global Compact on refugees, and I very much hope that's an issue we can come back to in our discussion. And I would encourage all 85 people who are participating in this session to submit their comments and questions in the chat function. And if I recall correctly, the last RLI conference when this issue came up, there was a kind of general consensus that such an independent mechanism would indeed be a valuable idea, but there was also a sense that neither states nor UNHCR would particularly welcome it. And that might be another issue that we want to come back to later. So we're going to move on to the third. I'm particularly interested in paper because I'm a historian by training, not a lawyer. And one thing you might have noticed is that history was really absent from refugee studies for many, many years, in fact, for many decades. But over the last 10 years or so, there's been a real resurgence of history in refugee studies. And I think that's a very healthy development. And so we are moving to a more historical paper next. Philip and Catherine are going to talk about questioning the origin story of the global refugee regime. So Philip and Catherine, the floor is yours. Thank you very much.
Okay, customary thanks to Jeff and of course the organizers. So the purpose of our paper is to discuss and historicize what we refer to as lost centrism and calls for reform in global refugee regimes. It's part of a broader project exploring the interwars legacy and contemporary discourses regarding global refugee issues. To be clear from the outset, we're skeptical of what we regard as this lost skepticism. It's not a hostility to legal development as such, and I wouldn't want it to be read as a direct criticism of Professor Gary's very considered and eloquent elaboration on how she would envisage a global court. Rather, it's a critical posture towards a number of assumptions which we believe that law-centric proposals appear to rest upon, and the possibilities that they foreclose. Our argument proceeds in 3 steps. First, we're going to highlight the way that law centrism is pervasive in both contemporary calls for reform and in the historical imaginary of the field. Secondly, we're going to focus on interwar population exchanges to challenge the idea that international legal regulation of refugees is inherently virtuous and that can function autonomously. Thirdly, we're going to offer some conclusions regarding the insights that this more complex history of refugee protection may yield in the context of contemporary debates.
So in these calls for reform, much of the current discussion focuses on how we can supplement or refine the existing refugee law framework. The call for more law is often the reflexive response to apparent crises of law's efficacy, and my fellow panelists have already discussed some of these narratives of this crisis of refugee law. And in the recent writings of James Hathaway, for example, this is manifest both in the call for further legalization of the field and a hostility towards so-called soft law instruments, such as the global compacts. Hathaway's proposals claim that what is required is an expansion of the binding legal regime to ensure access to an internationally managed protection system wherever a refugee seeks it, and an enforceable mechanism of burden sharing. And as Dr. Crisp has already raised, at the RLI conference last year, there was much discussion of what these mechanisms might look like. In the opening panel on injecting new life in international refugee law, there were 4 eminent refugee lawyers and practitioners discussing these different proposals. And this included much focus on an additional protocol to provide greater responsibility sharing and accountability mechanisms. Thus, the debate centres around the need for legal development. And so one would expect we are refugee lawyers at a refugee law conference. This reflexive call for more law in response to contemporary crisis finds its analogue in the historical imaginary of the field. While there are variations, the archetypal narrative grounds international refugee protection within an interwar problematic. There's vast displacement, nationalisation of states, hardening of borders, and so on. It locates the wellspring of the field in the development of a series of international legal devices, most notably the Nansen passport. This orthodox historical narrative treats the Nansen passport as the moment when international refugee protection assumed its true form, an internationally agreed definition of refugee status, and an individualised bundle of legal rights, which was then realised in the 1951 Convention. This sort of narrative conveys a clear sense of liberal progress towards an assumed true form, while simultaneously it's already encoded within it the prescription for future ailments, more law. As Jeff and Nick Maple say in their RLI blog on the refugee regime, this regime is and always has been far more than the legal framework, and also includes institutions, norms, principles, rules, and accountability mechanisms. Excessive focus on the legal framework as the key site of past and present reform blurs this insight and can exclude important episodes and preemptively foreclose potential avenues for further reform.
Okay, so the episode that we want to focus on, the episode that's contemporaneous to the development of the Nansen passport, but is generally excluded by orthodox histories of the field, are the interwar population exchange agreements, beg your pardon. The population exchange agreements were an attempt to peacefully catalyse the formation of nation states from the cosmopolitan territories of the Eastern empires. They sought to provide for redress for refugees already in motion, while simultaneously preventing future refugee crises arising by preemptively displacing and resettling minorities. In the case of the Greco-Turkish exchange, over 1.5 million individuals were resettled. While in the contemporary imaginary, international law is regarded as an emancipatory force that elevates the dignity of refugees and offers protection, the population exchange agreements were coercive in character. I should clarify that the Greco-Bulgarian agreement was ostensibly voluntary, but it rapidly assumed a coercive character in practice. While the population agreements sought to protect vulnerable peoples, many, as I've said already, were displaced. They were coercive, they were premised on a narrow vision of humanity, and they shoehorned complex identities into simplistic categories. From this alone, we should be cautious of assuming that legal interventions in the field of the refugee are inherently beneficial to displaced peoples. Beyond this salutary reminder, the operation of the population agreements offer a range of further insights in the way that these interwar legal devices were supported, operationalized, and rendered effective. Firstly, from the outset, it was recognized that integrating refugee communities into domestic economies, in other words, enabling refugees to become self-supporting economic actors, would require significant investment. In this regard, both Greece and Bulgaria were able to support refugee communities because of the provision of League of Nations-backed loans. This international financial support wasn't uniformly available, however. Turkey refused international assistance because of the legacy of international debt and its history in the Ottoman Empire. And meanwhile, Nansen's proposal to resettle Armenian refugees in the Soviet Caucasus foundered on the unwillingness of Western governments to contribute to the economic development of the Soviet Union. Nonetheless, despite the fact that around 20% of its post-war population was comprised of refugees, Greece was able to quite effectively assimilate these displaced communities, and by the end of the 20s, the net population gain, was widely recognized as a boon to Greek economic development rather than being a burden. Secondly, closely related to the provision of financial assistance was the development of autonomous administrative agencies to disperse financial support. So post-war, Greece had endured a tumultuous series of constitutional revolutions between monarchical and republican factions. At the time of the conclusion of the agreements between the League of Nations and the Greek regime, the de facto Greek regime had no constitutional authority. In order to insulate refugee resettlement from further constitutional upheaval, a series of semi-autonomous administrative organs were established, and they were established to insulate the disbursement of this finance from domestic change, and they transcended simple dichotomous distinctions between the national and the international. This sort of institutional arrangement is fairly commonplace today, but at the time they were revolutionary. As such, they serve to illustrate that we can seek transformative change, we can seek to realize transformative change through the reimagining of institutional forms as readily as through reimagining law.
So a more nuanced account of the international refugee regime's history can contribute to a clearer grasp of the potential directions of future reform. As I've said, more law is a general, if not universal, reflex when an area of law is perceived to be inadequate. However, as our discussion of the interwar population exchanges sought to make clear, law operates within a complex field of normative and institutional structures. Our consideration of the refugee regime's history demonstrates the importance of examining the wider context in which legal development would occur. It's thus necessary to consider the refugee law framework within the wider whole. This enables us to include what is necessary to support legal reform, but also what is obscured from the outset by assuming that law is the answer. In looking to the reform of the refugee regime, these additional aspects should be kept in mind. Law alone will not resolve or ensure sustainability of refugee protection. More specifically, let's return to the opening panel at the conference last year and the third presentation from Madeleine Garlick and Gillian Triggs. They explored how soft law can contribute to the development of norms, ensure the equitable sharing of the responsibility for refugees, and guide implementation across stakeholders through cooperative frameworks. Soft law international agreements seem to do two things then. They exert influence on the understanding of existing law through interaction with hard law. And second, they coordinate the framework required to realise these obligations through better responsibility sharing, cooperation and financing. And here we come back to the notion of regime as something more than the legal framework. A prime example of this is the already mentioned Global Compact on Refugees, a non-legally binding instrument that outlines a framework for improving international cooperation and responsibility sharing. Critiques have said that the compact does not go far enough, that binding law is necessary. However, calling for further codification ignores the residing political context and the fact that states have just negotiated the Global Compact, which operationalizes and contextualizes existing obligations to provide a guide to better implementation, and it sets out a multi-stakeholder, cooperative and administrative framework, as well as mechanisms for international financial responses to large-scale refugee situations.
Okay.
As demonstrated, history tells us.
Come to a finish, please.
Yeah, I'm on. Yeah, last couple of sentences.
Yeah.
As demonstrated, history tells us it's not just law, but it's institutions, international cooperation, financial support, and multi-stakeholder coordination that is needed. Whilst the Global Compact does have its flaws, we'd caution against an automatic fallback to creating more law to address challenges in the implementation of refugee protection, and question whether legal reform is the stage for ensuring better responsibility sharing. What is certainly needed is a strategy to improve political will and cooperation, which can incentivize states and other stakeholders to uphold their obligations, rather than trying to force greater compliance through more and more law. Thank you, and sorry for running over.
Right, thank you very much, Philip and Catherine. That was excellent. And we're going to move from a more kind of historical perspective in the last paper to a very contemporary issue, one that's really very much in the headlines these days, which is about the differential treatment of different refugee groups according to their place of origin. So it's a great pleasure for me to welcome Shardin to take the floor. And I should say before she speaks that it's her birthday tomorrow. So happy birthday to you tomorrow, Shardin. The floor is yours.
Thank you for the unique introduction, and also to the panelists that I'm sharing the floor with. It's my privilege and my honor to be here. And I'd also, I mean, given myself as an audience member right now, watching everybody else, I'd also like to really give a shout out to the organizers for the very intentional complementarity with which this was organized. I really learned a lot from you guys already. And with that, I'll jump right into it. Let me just get into a screen share. Apologies. So where this starts, sorry, just looking for that, yeah. So where this starts, essentially, what I'm trying to do here is take the conversation on differentiation beyond particular contexts. We know that I think that we've come across a lot of these analyses in different contexts around the world. Obviously, what's in the headlines right now is Ukraine, but there are kind of smaller pieces coming out that look at particular country responses and explain the differentiation there within. But what I want to do here is take a step back and see how this is kind of enshrined somewhat in the refugee regime and in the operationalization of the refugee responses and so on. Just moving straight on, that's self-explanatory. So the context for me, while I know that this was very relevant for the Ukraine response, was actually the Syria response. I was in Jordan during the time of the Jordan Compact and the implementation of the JRP and so on. And what I had observed in Jordan, in Lebanon, in Turkey, was the implementation, or rather the passing of both ad hoc and permanent or sustainable legal changes that accommodated solely a single group, in this case, mostly Syrian refugees. Best known in Turkey would have been the law on temporary protection, which took inspiration from the temporary protection directive in the EU. But in Jordan as well, you had the labor programs that came out that were specific to Syrian refugees and so on. So what I wanted to take a look at here is how is this actually applied beyond just these particular crises and particular historical explanations by context. Concepts I'm looking at here, I coined a term for the purpose of this paper just as an umbrella. And I specifically use nationality-based aid, protection, and inclusion to talk about the entire spectrum that is refugee policies. And the reason I use nationality here and not country of origin as in what is normally used when speaking of law is specifically because we don't look at country of origin actually. And this was most recently spotted in the Ukraine movement, in that obviously not everyone that came out of Ukraine was eligible for protection. I link a number of concepts here together. Firstly, I look at power asymmetry and the ways in which mutual interest can mean differentiated responses. And what I mean by that is that looking at, this was a concept introduced by Alexander Betts, I believe, but the idea here is that the global North and global South may cooperate on refugee issues when there is mutual interest. Given that there isn't always mutual interest, of course, this is immediately differentiation in the response. Similarly, we also look at individualized versus group or category approaches. I will say more on this later, but the idea there is to look at how individualized are we really in approaching or in supporting refugee responses or refugee movements and so on, given that we still tend to rely quite a bit on group approaches in assigning not necessarily refugee status, because many refugee hosting countries don't assign refugee status, but some sort of protection as applicable in their contexts. So what the premise here is that I know a path dependency of some sorts in reliance on emergency responses, coupled with a global power asymmetry that in a lot of host countries, particularly across the South, but frankly, we've seen this especially emerging more in Europe as well, nationality-based refugee policies, given that much of what is assigned or what is given as a refuge is where they're coming from and not necessarily anything else. So starting with a bit of origin, this is somewhat repetitive from what was said before, but I'll try and just focus on what was unique to this presentation. So starting from what is the contested sort of start of the modern refugee regime, if you would like to say, post-World War I. And that was the appointment of a High Commissioner for Refugees that was specifically appointed to address the needs of 5 nationality groups, and that was Russian, Bulgarian, Turkish, Armenian, and Greek refugees. And this was what was dubbed later as group approaches, category approaches. And it was not specific to the persecution of individual claimants, but rather, once again, this innate characteristic, their nationality. And it was broader, but also more narrow in what they sought to do. Moving forward a little bit, I here evoke the founding of the UNCCP, and at the time also the UNKRA and many other agencies that were specifically dedicated to specific refugee groups. But UNCCP, which eventually came to what we all know as UNRWA today. And this is a specific agency that maintains, so to speak, Palestinian refugees across 3 Levant states. Originally, you could argue this was a form of preferential treatment. As particularly in the same period, we had partition taking place, which obviously did not get its own agency or particular attention, but was also quite a large displacement of people. But this was, sorry, eventually, it was eventually continued, and it had stayed to today as the only, particular agency that was dedicated to a single group of refugees, despite obviously the ratification of the 51 Convention, the creation of the UNHCR. Problematically, there is no mandate over durable solutions, as we know, and there's a general exclusion from refugee-related discourse. I note that in many of these top 10 lists that were mentioned earlier in this panel, Palestinians are not normally included in that, despite the fact that it's quite a large group and are still not fully counted under UNRWA lists. So generally excluded from refugee-related discourse, given that the UNHCR expanded and became kind of the owner, so to speak, of this issue. I put this in line with now kind of the concepts I was talking about before. There is a divide in obviously the refugee regime and somewhat of an impasse between global North and global South, given that there is obviously going to be a differentiation in who can be addressed or what crises can be addressed. There will not, in many host states, particularly again in the South, that are dependent, so to speak, on the on the acquisition of funds to address needs of many different groups, particularly those that have high refugee populations. They would have differentiated responses accordingly. And this is particularly for those that don't necessarily have comprehensive refugee policies, and that would be a number of the majority host states that were mentioned earlier. Similarly, in parallel, you have what kind of emerges the discrimination versus delegation puzzle. So how do host states respond to these sort of things? As the regime evolved to become more maintenance oriented, you could say, and less about solutions or protection or illegal mandate, a number of things that were introduced here today. I don't want to repeat a lot of what was said, but as this became an increase, essentially a reliance on host states, particularly in the South, accordingly, responses differentiate due to limited resources, frankly, different political affiliations, as we know, meaning that there is also differentiation based on diplomatic relations with the sending state, with ethnic affiliation, how easy is this to sell, quote unquote, to the population that is receiving, and further, how much funding are they getting to handle the population that's coming in? And given that, it does not mean that even if they were to get So looking at the Syrian refugee response in Jordan, if they were to get funding for the Syrian refugee response, this does not mean it's also funding for the Iraqi refugees that are present in the country, or arriving Somali and Sudanese refugees or Yemenis and so on. That's a key distinction here, because this is not refugee responses that are based on emergencies are normally going to be limited in practice, although it's not necessarily always mentioned, but in practice it is always limited, or almost always limited, to the group that is part of this emergency. And given that, that there is differentiated responses and relying on emergencies here, obviously, so I mentioned here 3 types of humanitarianism. That's the transformative, alleviation, and emergency response. I focus on the last of these. Especially in emergency responses, there is invisibilization, to quote Maya Yanmir, of smaller groups. And that is related to the construction of needs accordingly. So given that if there is funding, obviously, that comes in for a particular group that is deemed to be in an emergency situation, the needs and the hierarchies of protection accordingly are constructed for that group. And the priority tends to be given to bigger, better funded responses. And this particular piece that Maya Yanmir, who I quote here, is speaking about is of Sudanese refugees in Lebanon, and particularly of the role that UNHCR plays in how they are more marginalized and the difficulty in accessing protection status and in registration. And this can be very much seen in a lot of parallel contexts, right across borders to in Jordan, in Turkey, and so on, how much more difficult it is for other groups to get access to the same protection and aid and so on. Accordingly, I state here that refugee aid policy between these several factors that I mentioned can reinforce horizontal inequalities between different groups, and means that certain demographics have better access. So it does not just stop at protection and access to registration, but registration obviously impacts the next step too, and that is aid and cash assistance and so on. And here, just for like a bit more on how emergency responses would work and the implications, rather legally speaking, is how we use prima facie determination of group refugee character. And I mentioned this here specifically to say that, once again, we do talk about the individual character of the 51 regime, but in practice, we do still use these group approaches quite a bit when we're talking about refugee responses. And it's in the language that we use: the Syria crisis, the Ukraine crisis, so on. And it's not necessarily a critique of that language, but rather that it's an assumption that it's all encompassing, but it's rather not. And they have, the problem with it isn't necessarily the practicalities. The practicalities are quite evident in why you would do this for large influxes, but rather it's for the unintended discriminatory effects that are involved, given that, once again, smaller groups tend to be marginalized in this process. So looking at Jordan, again, I go back to this because this is what started the whole thing for me, but I would say that this is quite present in other contexts as well. Status was given automatically at one point. This has since mostly closed for Syrians in Jordan, while registration was highly restricted for minority groups who had to go through refugee status determination, and has since actually de facto closed completely, even for newer arrivals. Palestinian refugees from Syria were actually rejected altogether, despite having come from the same spot. And there was a bit of an irony, of course, in the history there, but they were rejected altogether. And those that did come in had to either falsify documents or had to find other illicit ways to come in, and those that did manage to come in and were found out, many were also sent to the Palestinian camps, the UNRWA-run camps. So I speak here of impacts, but I kind of went into a little bit, but so to speak of parallel context, what's going on, you've got what was mentioned earlier, Yemen was dubbed as a victim of geography. There was more politically contentious crises going on. So even though that Jordan received a number of Yemeni refugees, the aid that was given, there's quite a big response at the beginning, was not dedicated to those groups at all, except with very, very minor exceptions, given cash assistance and so on. Other things are like the EU-Turkey deal and resettlement. While this is obviously considered to be a largely failed deal, I will wrap up shortly. Obviously I was linked to largely considered to be a failed agreement, but the resettlement under that was still linked to Syrian refugees, despite the fact that we do talk about many of these host countries as hosts of many refugees. Now, move on there. This is just a quick overview of also other examples of embeddedness of inequality, but I will just note one of them here. But on the explicit expulsion of Tunisian asylum seekers, while other groups have systematically higher recognition rates, this was a case in 2019. I am particularly pointing out these kind of less or more ambiguous examples, specifically to show that it's not simply the Ukraine crisis. There's actually been a history of this. This is just the most, I think, the largest, most pressing example, you could say. So accordingly, just to wrap up here, I come to three general or kind of linked conclusions. That firstly, the differentiation here is very clearly embedded in the overall structure. The largest refugee groups, or one of the largest refugee groups, sorry, and if even larger if you're counting descendants, are excluded from the UNHCR by default. So you can talk about that at the largest level. But continuing from that, there is no overarching refugee policy in a lot of countries. Accordingly, despite law, they can respond to things ad hoc. And also, accordingly, that there is a role of the international community in reinforcing that, given that they also have selective interests in which crises they would like to support and who is rather producing more refugees versus displaced persons and so on. And with respect to time, I will leave it there and hope for some discussion. Thank you.
Great, thank you very much indeed to all of the panelists. We've got some great questions that have come in on the chat. I guess you could divide them into kind of two categories. Some are rather kind of general and far-reaching. The others are slightly more technical and legal. So I'm going to start with the more general questions. And a really great question from somebody from he or she doesn't say which country they come from, but it's a country with a large number of internally displaced people. And the basic question is, why has the refugee regime excluded internally displaced people? Why is there not the same structured approach to the protection of IDPs as there is in relation to refugees? And I think we could also link that to the Global Compact, in the sense that the Global Compact very rigorously excluded any reference to internally displaced people and basically shoveled off the whole issue to a separate high-level UN panel to look at, which reported, I think, about a year ago. So who would like to take on this challenge of explaining why there's been a less structured approach to the protection and solutions for IDPs? Why has the focus been so much on refugees? Anybody feel confident to have a go at that one?
I don't mind making a start, and then others.
Kathleen, let me add to that. Do you think we actually are moving in the direction of some kind of a regime for internally displaced people?
Adding in a little extra question there.
Yeah.
I think in terms of why internally displaced persons are not included in the structural protection, if we look back kind of historically to the development of the kind of the understanding of what a refugee is, or and kind of what was understood at in the interwar period where these first instruments developed, it was an understanding of someone who was outside of their country of origin without the protection of their country of origin, and that was what deemed these individuals as worthy of this special type of protection, this different response to other individuals affected by the conflict, or at least as I understood it, and the need to respond to the huge swathes of people who were displaced at this time. And I think that understanding has then continued. And so seeing internally displaced people as of a slightly different category because they remain in their country of origin and potentially under some form of protection of that country. I do think that there is a regime, in answer to your second question, Jeff, that there is an emerging regime to respond to this through the guiding principles on internally displaced persons, and regional responses that do specifically provide structures of protection to internally displaced people. So I think we are recognizing that these are a group of people who also require specific forms of protection. But I think it's this, from our perspective of our paper, I suppose this historical understanding of what was being responded to saw refugees as a very particular group. Others may come in. I'll stop there.
Great. Let's, in the interest of time, let's move on to another general question which has been posed by one of the participants, which is essentially, what are your views on the implementation of the Global Compact on Refugees? To what extent can it be seen as a success or failure in meeting its objective, and particularly the objective of more predictable and more equitable responsibility sharing? I think we should remember that, if I remember correctly, that the Global Compact started out as a Global Compact on responsibility sharing. And I think at some point in the negotiations and discussions, the reference to responsibility sharing was actually dropped. And one of the criticisms that is made of the compact is it's generally supportive of responsibility sharing, but doesn't make any specific demands or obligations on states in that respect. So who would like to offer some kind of general assessment of the Global Compact on Refugees? It's been in place for 3 years now. Has it achieved anything? Is it likely to achieve anything? What are its strengths and weaknesses? Anybody want to have a go at that one?
I could maybe start, and happy for others to contribute. I mean, that's a terrific question, and it's created a lot of hype, the Global Compact on Refugees. And related to the other question and some of the comments, you know, there has been a distinct process for migration. I'll be honest, I think that causes confusion. It's all about human rights at the end of the day. And even, you know, to add to what Catherine mentioned for IDPs, I mean, there are specific legal regimes for IDPs. It's called international human rights and domestic human rights. So, but the Global Compact on Refugees, look, it's here. We can't kind of put the train back in the station, I don't think. But I think we should look at it critically. I mean, what has it achieved after 3 years? And if you listen to what UNHCR has to say about it, last year was a write-off, or the last 18 months were a write-off because of the global pandemic. I mean, in fairness, there's some truth to that. But it really has become, and you know, to use James Hathaway's terms, you know, a major talk shop. But we also have NGO consultations, we have resettlement consultations, we have an executive committee, we have lots of talk shops, we have a UNHCR presence in the field in an extensive number of countries that are interacting with governments all the time. And frankly, I'm quite convinced that all those pledges that were made at various enormous events that take, you know, hundreds, if not thousands of hours of staff time, which frankly, we have to aggregate, it costs money, would have come anyway if UNHCR had asked. And they had asked, and even there was a lot of fanfare about hooking up with the development banks, but that was started well before there was a Global Compact on Refugees. So you know, maybe the fruition was showcased during the major adoption of the GRC and major conferences, but it was discussions that have been going back well before. And I think the engagement of the development banks would have come regardless. I'm not that personally. I think there's a real attempt for UNHCR to try and remain relevant. Hence my comments earlier about you know, branding and being in the public space. And it relates to another question that somebody raised, a very good question. You know, saying that, you know, does UNHCR consciously or unconsciously compete for resources? It very consciously competes for resources. It has to, but at the same time, the ethos is always bigger is better. And another, you know, comment I made is that, you know, why does UNHCR have to do everything? And when there's a new crisis, it has to, you know, be the first one in line. I mean, I think it's losing some of its protection soul as a result. And possibly with less funding, it could become a more orthodox protection-oriented institution, which it was initially created to be, rather than being beholden to states that probably even promote the idea that, you know, UNHCR in particular is asking for more funds, constantly asking for more funds, constantly bigger budget. And being beholden in that situation compromises its ability to speak out protection-wise. When you're going to the same handful of states literally for funding. So I'd be happy to have others contribute to that.
Thanks. I think in the interest of time, I'd like to move on to another issue, which, I mean, I've been working in this area for a long time and I've never seen this question posed before. And I think it's a really interesting one. So I'd be interested to get your perspective. And the question is, how do we explain the fact that out of all the kind of the possible grounds of persecution in the 1951 Convention, that race is the first one listed in that? Is there any significance to the fact that race is listed as the first grounds of persecution on which you can claim refugee status? And the questioner goes on to say, to what extent does that notion of race actually dictate whether or not asylum seekers receive protection from certain countries and continents under international refugee law? So it's certainly, in my experience, an issue that the race issue is not one that's been explored in great depth. I'd be interested to hear anybody who's got any reflections on that dimension of the issue.
Might I come in?
Yeah, sure.
I was thinking, I did notice it in the chat, and I had kind of a bit of like a think about it, but I don't know if it's particularly deliberate in this fact that it's coming first, but I would say there is somewhat of something to be said about the fact that you mentioned race there and not citizenship. I feel like it's more of a limiting factor in this idea. I find that these grounds that were laid out in the convention, or rather the grounds of persecution, are done because the assumption that is underlying it is that the real refugees, genuine refugees, whatever you want to call it, are inherently, this will always be a limited group. It's not, the assumption is never to be that there is going to be this large, group of people that qualifies to be a refugee. I see using race here as actually a cop-out from using citizenship or country of origin in a lot of ways, because normally what is happening in a lot of contexts is rather that the country has become unsafe. So we can't say citizenship because that automatically qualifies, X million people as grounds of persecution, even though, once again, there's a lot of this happening in practice. But I think realistically speaking, that's kind of what I would take away from that. And it also somewhat could be a reflection of the period in which this came out, of course, given obviously this is post-World War II, and how I would see, that there was particular groups that were being persecuted in this period. So it was kind of using language that was, I think, a result of that period. But yes, I would relate this more to the fact that we don't want to use the word citizenship, given that that is still the term that we classify responses with. But I'd be happy to hear from the others.
Yeah, thanks a lot. Maybe I could jump from that to a question of my own, which is very much related to the future evolution of the refugee regime, which is, in terms of grounds of persecution, of course, there is quite a strong lobby that has been around for some time now, asking for the notion of climate refugees or climate displacement to be added to the convention grounds. I think there's also kind of a lobby for either gender or sexual orientation to be included under specifically, rather than just the more general membership of a particular social group. I just wonder what the panelists think about what are the prospects for adding to the grounds for persecution in the 1951 Convention. Is that a likely development that might take place in the future? And in your opinion, would it be a welcome development? Anybody want to have a go at that one?
I'm happy to jump in again if others don't.
Sure.
I would say that this is actually very much linked to what I just said. I think that's not going to happen, but for the particular reason that there is, again, the Refugee Convention by definition, assumes that there is only a finite number of actual refugees. I think climate refugees is an infinite number, and it will be an infinite number in the future, given that we can't limit it. Would you make it regional? I mean, how would you even classify this? Would we say it's a small island states? Would you say it's the Gulf states as well? Because that's soon going to be uninhabitable. And that's by default, you're talking about millions of people. I think the framework that if one is to actually emerge is going to be more similar to regulating labor migration and temporary labor movements. Given that a lot of climate movement as well, obviously there's the two types, but you can say there's a slow onset and the more rapid. And I think that it's going to be more like temporary. This is what I imagine, of course, with temporary labor migration, similar to those frameworks, obviously not the same, given that those are more accommodated or more understanding of larger movements. Even if in practice it doesn't necessarily do that, but that's the assumption that drives those.
Okay, thank you very much. I think we're checking, all out of time. We've just got 1 minute. I've got a question here, which I think will have to be the last one. What would your main recommendation be for lawmakers and the international community to finally provide equality and safety to all refugees and asylum seekers, rather than prioritizing specific groups based on their nationality, culture, or religion. And I guess this issue has really been brought to the fore very much by the differential treatment of Ukrainians and other refugees, particularly in Europe. Is it an inevitable feature of the refugee regime that states and citizens will treat some people more generously in a more welcoming attitude than others if they feel there's some kind of affinity with them on the basis of ethnic background, religion, language, politics, etc.? Or can we envisage a refugee regime, which, as the questioner has just asked, can we envisage a regime in which all asylum claims are treated on a genuinely equal basis?
I would take a stab at that. There's nothing wrong with the regime, and the two red threads in international law are non-discrimination and equality, and those are present as well in the the normative architecture of international law governing refugees. Where we have differences, of course, is the politics, and the politics of how states will fund and prioritize, as some of the presenters provided historically. And also in today's world is something that drives, I'd say, the inequality and, if you will, the discriminatory approach that states take for particular groups of refugees. But there's nothing particularly wrong with the law apart from it being implemented in a politicized fashion.
Okay, great. Thanks very much, Brian. We have unfortunately come to the end of this session. So let me take the opportunity to thank all the panelists for some very stimulating contributions to the discussion. A great way to start the conference, I think. And thanks to all of the participants who submitted questions. I'm sorry we couldn't get to all of them, but I'm sure we'll preserve them and make sure that they're forwarded to the panelists. So with that, thanks very much.